You think a little girl from the South Side is going to walk into my hospital and tell me how medicine works?" Dr. Raymond Holt crossed his arms, his voice carrying across the entire nurses' station like he wanted witnesses. "Go back to your mop, sweetheart. Leave the diagnoses to the people who actually went to school." The laughter that followed was quiet, but it was there. Orderlies pretending to look at clipboards. A charge nurse suddenly very interested in her computer screen. And Camille Washington, 22 years old, standing in the middle of Mercy General Hospital's 3rd floor in her pale blue scrubs, holding a patient chart that she had just spent 4 hours cross-referencing against a pharmacology database, feeling the heat rise to her face. They laughed. Holt walked away without looking back. Everyone in that hallway assumed that was the end of it. They had no idea that what Holt had just done, in front of 6 witnesses and a security camera, angled directly at the nurse's station, was hand Camille Washington the first piece of a case that would eventually end his career, cost the hospital $14 million, and change the way Illinois hospitals were legally required to report medication errors for a generation. But that morning, Camille didn't know any of that yet. She just knew her mother was dying in room 318, and the chart in her hands proved it didn't have to be that way. Dorothea Washington had worked the same corner booth at Lena's Diner on 63rd Street for 27 years. She knew her regulars by their coffee orders and their grandchildren's names. She remembered birthdays. She slipped extra biscuits into the bag when she knew someone was having a hard week. She was the kind of woman that a neighborhood is built around, without anyone fully realizing it until the day she's gone. The diabetes had come on slow, the way it often does. A number here, a dietary restriction there, nothing that felt like a crisis, until suddenly it was. Dorothea had managed it carefully, on a tight budget, with a doctor she saw twice a year, and a pharmacy on Halstead, where the pharmacist knew her name. She was not a woman who complained. She was not a woman who asked for help unless the situation had moved well past the point of pride. In March, Dorothea had checked herself into Mercy General with elevated blood sugar and pain in her left foot that had gone from a throb to something else entirely, something that woke her up at 2 in the morning and left her gripping the edge of her mattress. The admitting team had given her a bed, a diagnosis of diabetic neuropathy with early signs of infection, and a treatment plan that Camille, who had driven over the moment she got the call, had tried to read in the waiting room. Camille was not a doctor. She was a second-year nursing student at Malcolm X College, working night shifts as a patient care technician at a different hospital across town. She knew enough to follow a treatment plan and enough to recognize when something looked wrong. What she saw in her mother's chart looked wrong. The attending physician, Dr. Raymond Holt, had prescribed a standard broad-spectrum antibiotic for the foot infection. That part was fine. What was not fine was that the same chart, 3 pages earlier, clearly listed Dorothea's documented allergy to that specific class of antibiotics, a reaction from 12 years ago. Hospitalization. The notation was right there in red text, in the allergy section that every intake nurse was required to complete. Camille had brought the chart to the nurse's station. She had been calm. She had pointed to the page, then to the prescription, and said, clearly, and without accusation, that she believed there may have been an error, and she'd like to speak with someone about it before the next medication round. That was when Dr. Raymond Holt had walked out of a patient room, taken one look at her, and decided that the most efficient use of his time was public humiliation. He did not look at the chart. He did not look at the allergy notation. He told her to go back to her mop, and he walked away. 20 minutes later, a nurse administered the first dose of the antibiotic to Dorothea Washington. By that evening, Dorothea was in the ICU. The allergic reaction was severe. Dorothea's airway began to close within the hour. The crash team got there in time, barely, and what followed was 3 days of stabilization, a medication correction, and a quiet, institutional closing of ranks that Camille would only fully understand weeks later. When she tried to ask about the incident, the floor nurse told her these things happen and that the care team was monitoring the situation. When she asked to speak with a patient advocate, she was given a number that rang to a voicemail that was never returned. When she asked for a copy of her mother's updated chart, she was told that requests needed to go through medical records, and there was a processing time of up to 30 business days. When she asked Dr. Holt directly, standing in the corridor outside the ICU with her hands shaking at her sides, He looked at her with an expression that was somehow both bored and contemptuous at once. "Your mother received the standard of care," he said. "Adverse reactions are a known risk. I'd encourage you to speak with our billing department about any financial concerns." "What?" He said it the way a person says it when they mean the conversation is over. Then he walked away. Again. That night, Camille sat in the ICU waiting room on a chair that had a tear in the vinyl that had been patched with packing tape. She didn't sleep. She pulled out her phone and started taking notes. Everything she remembered. Times, names, exact words, the name of the nurse who had administered the medication, the timestamp on the allergy notation in the chart, the exact words Dr. Holt had said at the nurse's station, and the approximate location of the security camera she had noticed on the wall behind him. Her mother was alive, but the infection had progressed during the window when the wrong medication had disrupted her system, and now the doctors were using the word amputation in the same breath as, "We'll know more in a few days." Dorothea Washington, who had stood on her feet for 27 years, serving coffee and comfort to a neighborhood that needed both, might lose her left foot because a doctor had not looked at a chart and had chosen, instead, to mock his patient's daughter in front of an audience. Camille was not going to let that disappear into a voicemail box. She spent the next 3 weeks learning things she had never expected to need to know. She already understood hospital systems better than most people her age. But understanding how a floor runs is different from understanding how a hospital protects itself when something goes wrong. And that knowledge lived in a different set of documents entirely. She started with the Illinois Department of Public Health's patient rights statutes. Then she moved to the federal HIPAA privacy rules, and, more importantly, the sections that specified what a patient's authorized representative was legally entitled to access. She read the Joint Commission's standards for medication administration and error reporting. She read the hospital's own publicly filed compliance reports from the last 5 years. It took her 11 days to find the specific provision she needed. Buried in Illinois Administrative Code Title 77, the Health Facilities Regulations, a licensed hospital in Illinois was required, under state law, to complete an internal incident report within 24 hours of any adverse medication event, and that report was required to be made available to the patient or their authorized representative upon written request, separate from the standard medical records process, with a response window of 10 business days rather than 30. Camille had not been told that. Nobody at Mercy General had mentioned that the incident report existed, let alone that she had a legal right to request it. She submitted the written request the following morning, citing the specific code section, the specific incident date, and the name of the attending physician. She sent it certified mail to the hospital's risk management office, the patient advocate office, and the chief medical officer. She kept copies of everything. She also, quietly and without announcing it to anyone, filed a formal complaint with the Illinois Department of Public Health. Then she went back to the hospital and sat with her mother, who was beginning to understand that the foot might not be saved, and who kept saying, "Baby, don't make trouble," in a voice that broke Camille open every single time, because Dorothea had spent 27 years not making trouble, and this was where it had gotten her. "I'm not making trouble, Mama," Camille said, holding her mother's hand. "I'm just reading the rules." The incident report arrived on the 9th business day. It was 42 pages, heavily redacted, and clearly prepared by someone who had expected that whoever received it would not know what they were looking at. Camille knew exactly what she was looking at. The redactions covered the names of staff members, which was permissible. They did not and could not cover the documented timeline of events, the medication order timestamps, or, critically, the section titled Identification of Precipitating Factors, which was required by law to contain a factual account of what had preceded the adverse event. In that section, under the heading completed by the risk management coordinator, was a single sentence that the coordinator had apparently not realized was as damning as it was. It read, "Prescribing physician was verbally informed of potential allergy, conflict by family member prior to medication administration. Physician determined clinical judgment superseded notation." Camille read that sentence 4 times. Then she read it again. Dr. Raymond Holt had not missed the allergy notation because he was busy, or because the chart was confusing, or because the system had failed. He had been told directly, by her, and he had decided his judgment was more important than documented medical history. And then his own hospital's internal incident report had recorded that fact, presumably because the risk management coordinator was filling out a required form and had not fully processed what they were writing. They had handed her the needle. Just like that. Buried in 42 pages of black bars and administrative language, they had handed her the exact sentence that made everything else fall apart for them. But Camille had been doing her research, and she understood something important about what she was holding. The incident report alone was a document. What she needed was a witness who would confirm it, someone whose testimony would lock the hospital into the version of events they had already recorded, so that when she produced the document, they couldn't reframe it or walk it back. She needed to ask the right question to the right person before they realized what she was building. Dorothea's foot was amputated on a Thursday morning in April. Below the knee, the surgical team was kind and the recovery nurses were excellent, and none of that changed what had happened, or what it meant for a woman who had built her entire livelihood on her ability to stand. Camille was in the waiting room when the surgeon came out. She listened to everything he said. She thanked him, and then she went to the hospital's patient liaison office, which she had never visited before, and she asked to speak with someone in risk management about filing a formal grievance. Not a complaint, a grievance. Specific language, specific process, specific legal weight. The woman at the desk looked at her for a moment. Then she picked up a phone. A man named Director Philip Carey came down 20 minutes later. He was in his mid-50s with the particular energy of someone who spent his professional life managing situations before they became problems. He had a kind face that he used professionally. He offered his condolences about Dorothea. He said the hospital took patient safety extremely seriously. He said there were processes in place and he wanted to make sure. Camille let him talk. She had her notebook open on her knee, and she was writing down everything he said, and he either didn't notice or assumed it didn't matter. When he finished, she asked him one question. In your hospital's incident report for the adverse medication event involving my mother on March 14th, the precipitating factors section states that the prescribing physician was verbally informed of a potential allergy conflict prior to administration and determined that clinical judgment superseded the notation. Is that an accurate characterization of the event as the hospital understands it? Director Carey's kind face did something complicated. I'd have to review the specific document, he said carefully. Of course, Camille said. I have a copy here if that would help. She placed it on the table between them. She watched him read the sentence. She watched him understand what she had just done. I want to be clear, she said, her voice steady, that I'm asking whether the hospital stands behind the documented account in its own internal report, not whether there are additional factors. Whether that sentence is accurate. Carey looked at the document. He looked at Camille. He was, she could see, a man doing rapid calculations about what the next 10 seconds would cost him. That document reflects the preliminary findings of our internal review, he said. So the hospital's position is that the document is accurate. That is not precisely what You've confirmed the document reflects the hospital's internal findings, Camille said. I have that on record. Thank you, Director Carey. She closed her notebook. She gathered her copy of the incident report. She stood up and said she appreciated his time, and she walked out of the office. In the elevator, she allowed herself to breathe. What followed moved faster than she had expected, and slower than she needed. She filed a formal medical malpractice complaint with the Illinois Department of Financial and Professional Regulation against Dr. Raymond Holt, citing the specific incident, the incident report language, and the verbal confirmation she had received from the hospital's own director of risk management. She filed a concurrent complaint with the Illinois Department of Public Health against Mercy General Hospital for failure to adequately respond to a documented allergy conflict and failure to inform the patient's representative of her rights under Illinois Administrative Code Title 77. She also found an attorney. This part was harder than she expected. 3 firms she contacted told her that without a retained expert witness, malpractice cases were difficult to move forward, and they weren't taking new contingency cases in that category. A 4th firm, a smaller practice on the north side, run by a woman named Adrienne Cole, called her back the same day. Camille emailed and said she had read the incident report language and she wanted to meet. Attorney Adrian Cole was direct in the way that people are direct when they don't have time for performance. She told Camille that what she had was unusual, that most families in her situation never obtained the incident report at all, let alone manage to get a risk management director to verbally confirm its contents on record. She said that the case had significant merit. She also told Camille that the hospital would fight, that Raymond Holt had privileges at 3 hospitals in the city, and had friends in the kind of places that made litigation expensive and slow, and that Camille needed to be prepared for the possibility that this would take years, and that the other side had far more resources. Camille thought about her mother learning to use a prosthetic in a rehab facility on the south side. She thought about the diner on 63rd Street, with the help wanted sign in the window that Dorothea had not been back to see. "I'm prepared," she said. The administrative hearing before the Illinois Department of Financial and Professional Regulation took place 8 months after Camille had first stood at that nurse's station with the chart in her hands. It was not a courtroom. It was a conference room on the 14th floor of a building in the Loop, with fluorescent lighting and a long table, and 3 members of the medical review panel who had the particular carefully neutral expressions of people paid to be impartial. Dr. Raymond Holt arrived with 2 attorneys and an air of composed irritation, the expression of a man who considered this a bureaucratic inconvenience rather than a genuine threat. He had a 40-year career. He had admitting privileges at 3 hospitals. He had a conviction, not a legal one, but a personal one, that the system he had operated within for 4 decades would ultimately recognize itself in him and make the appropriate adjustments. He looked at Camille Washington, 22 years old, sitting across the table in a blazer she had borrowed from a classmate, and his expression said what his words at the nurse's station had said 8 months earlier. He did not take her seriously. Some people cannot update that particular assessment, no matter what evidence accumulates, and Raymond Holt was one of them. The panel chair, a woman named Administrator Voss, opened the proceedings and asked Dr. Holt to describe his recollection of the events of March 14th. Holt's attorney had prepared him carefully. He described a routine clinical encounter, a judgment call made in the context of competing factors, an adverse outcome that was a known statistical risk of treatment, a family member who had been understandably distressed, and who may have raised concerns in a manner he had not fully registered in the moment. "May have raised concerns," Administrator Voss repeated, looking at her notes. "Dr. Holt, are you saying you are uncertain whether the patient's representative spoke to you prior to medication administration?" "In a busy clinical environment," Holt said, "there are many interactions in the course of a shift. I responded to what I assessed as relevant clinical information." "I see," said Administrator Voss. Camille's attorney did not raise her voice when it was her turn. She simply placed 3 documents on the table. The incident report. The certified mail receipt showing Mercy General's Risk Management Office had received Camille's request within the 10 business day window, and the notes Camille had provided, time-stamped, written the same night as the incident, recording the exact words Holt had used at the nurse's station, and the names of 6 individuals who had been present. Then Adrian Cole asked Dr. Holt a single question. "Dr. Holt, your hospital's own internal incident report, completed within 24 hours of the adverse event by Mercy General's Risk Management Department, states that you were verbally informed of a potential allergy conflict by the patient's family member prior to medication administration, and that you determined clinical judgment superseded the notation. Is that document's characterization of your decision inaccurate?" Holt looked at his attorneys. His lead attorney made the smallest possible movement with 2 fingers that meant, "Don't answer that directly." "The incident report reflects a preliminary internal assessment," Holt said. "It is not a legal finding." "I'm not asking about its legal standing," Cole said evenly. "I'm asking whether the factual characterization of your decision is inaccurate, yes or no." "I would characterize my decision as an exercise of clinical judgment in a complex situation." "So, you do not dispute that you were informed and that you made an active decision to proceed?" A pause that lasted approximately 3 seconds and cost Raymond Holt everything. "I made a clinical judgment," he said. "Yes," Adrian Cole said quietly. "You did." She set the documents down and looked at the panel. She didn't say anything else. She didn't have to. The panel's findings took 6 weeks to arrive in writing. The language was careful and thorough and unambiguous. Dr. Raymond Holt had demonstrated a failure to meet the standard of care required of a licensed physician in Illinois by proceeding with a medication order after being informed of a documented allergy conflict by the patient's authorized representative. The panel found that his failure constituted professional misconduct under Illinois Medical Practice Act, subsection A5 and A22. His license was suspended pending a formal disciplinary review. Mercy General Hospital, cited in the concurrent DHPH complaint, was required to implement mandatory allergy verification protocols with dual ERM sign-off, and to conduct staff training on patient representative rights under Illinois Administrative Code, Title 77. The hospital also entered into a civil settlement with Dorothea Washington, the terms of which were confidential, but which Adrian Cole later described, with the particular careful neutrality of someone who had won, as appropriate. The regulatory finding was forwarded to the Illinois State Legislature's Health Committee, which had been considering revisions to the hospital reporting statutes for 3 years without significant movement. The Camille Washington complaint, as it came to be referenced in the committee's internal documents, provided a concrete case study that moved the revision forward. 6 months later, the Illinois Patient Safety Reporting Enhancement Act was signed into law, expanding the mandatory disclosure requirements for adverse medication events and requiring hospitals to proactively inform patients and their representatives of their rights to instant report. Access at the time of the adverse event, not after. Adrian Cole called Camille the morning after the governor signed the bill. She read her the relevant section title, Patient Representative Notification Requirements. She said the committee staff had cited the case by name in the legislative record. Camille didn't say much. She was in the rehab facility on the south side, sitting next to her mother, who was learning to walk with a prosthetic and who had not yet been told about the law. "Mama," Camille said, after she hung up. "You know that chart I showed Dr. Holt?" Dorothea looked at her daughter, who was 22 years old and had never once, in all the months since March, cried in front of her. "What about it, baby? They put your name in a law." Dorothea Washington was quiet for a moment. Then she made a sound that started as something else entirely and became, slowly, a laugh. Not the polite kind. The real kind, deep and startled and full of something that had been waiting a long time to come out. She reached over and took her daughter's hand, the same way Camille had held hers in the ICU waiting room the night this all began, and she held it tight. "You read them the rules," Dorothea said. "I read them the rules," Camille said. Outside the window of the rehab facility, Chicago was doing what Chicago does in November, cold and grey, and utterly indifferent to the small moments that change everything. But, in that room, something had shifted permanently. A doctor who had looked at a young black woman and seen someone beneath his notice had, in doing so, handed her exactly what she needed to dismantle 4 decades of untouchability in a single afternoon. A hospital that had tried to bury its mistake in 30 days of processing time and 42 pages of redactions had instead written the evidence into its own record and handed it over because the law said they had to, because Camille had found the law and cited it precisely and sent it certified mail. The system had tried to close ranks the way it always does, quiet and efficient and practiced, but it had forgotten that the rules it relied on to protect itself were written down, that they were public, and that some people, given enough time and enough reason, will read every single page. Dr. Raymond Holt's license was permanently revoked 14 months later, following the formal disciplinary review. He did not return to clinical practice. The nurses' station on the 3rd floor of Mercy General Hospital got a new security camera, part of a broader facility upgrade, and a posted notice beside it that read, in 14-point font, "Patient representatives have the right to request incident reports. Ask a staff member for assistance." It was a small sign. It was there because of Camille Washington. Dorothea went back to the diner on 63rd Street 8 months after the amputation, not to her old booth. She couldn't stand a full shift yet, and she was honest enough with herself to know she might not again. But she went back for the Tuesday morning rush, and she sat at the counter and drank coffee that someone else had poured, and her regulars came in one by one and saw her there, and the morning was, by every ordinary measure, unremarkable. It was the best morning she could remember in a very long time.